The next case is Twinsburg City School District Board of Education versus Twinsburg Hospitality Group LLC et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments if that applies. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Good morning, Your Honors. If it pleases the court, I just want to recognize my esteemed opposing counsel, Mr. Seed. He and his partner, Mr. Brinza, do just an excellent job representing the school districts on matters like this. And I really hope that we can present a good case for the court to consider today from both sides. Obviously, I hope that you side with the appellant. My name is Dean Van Dress, and I do represent Summit Hospitality Group, which is kind of a smaller, medium-sized hotel, a comfort inn in Summit County, Ohio. Has around 70 units. The issue that we're dealing with today is an issue of diminished tax valuation that was caused by a very special Senate substitute Senate Bill 57, which was passed by the 134th General Assembly in response to valuations during the pandemic. So this is a very, very narrow issue before the court, and I hope to kind of explain and help, explain why we're here today. So normally on these tax valuation cases, we have kind of a 5-step process. The auditor or the fiscal officer would value the property. Then the landowner would get, kind of an informal letter type in the mail and could respond to it. Then if the landowner isn't happy with that, then it would go to our local board of revisions, and that's more of a formal process. Then after that, they have the option to go to the BTA, which is the Board of Tax Appeals, or appeal to the Court of Common Pleas. After that, then we would be here before you at your Court of Appeals, and then ultimately perhaps the Supreme Court. COVID, this special issue, differs from that process, and I just kind of want to explain why it's different and maybe why we're here. The normal process for non-COVID cases, the valuation is as of January 1st of the tax year, so that would be the tax lien date for valuation purposes. And the complaints are filed by March 31st of that tax year. For the COVID, the special law, it's diminished value as of October 1st of 2020, and those complaints were to be filed within 30 days of the law taking effect, which was done. The standard in the Board of Revision cases for normal cases is probative and credible standards. However, you'll see language in the substitute Senate bill which says satisfactory evidence. So we believe that that's an important distinction in terms of the type and the quantity and quality of evidence that you would need to present to substantiate your case.
Does this COVID revision statute say anything different about appeals, or beyond that, that's the only main language is satisfactory as the evidence needed, and you would follow the same appeal process under 57-1704, whatever we calculate?
I believe that following 57-1704 would be the natural process to appeal to the Board of Tax Appeals, Your Honor. I hope that answers the question. There are... Yes.
There was nothing in the text of the statute that said, in these cases, your appeal will be this instead of the normal appeal process.
Correct. It did not say otherwise. So we have treated it, the industry has treated it as that is the normal appeal process, is the flow, the general flow is what we said. I would like to reserve 3 minutes. I did say that at the beginning, but if I could. And then the other difference is that on a normal tax valuation complaint, there's actually a form which is called the DTE1. You'll see in this case, and it's in the record, that this form is the DTE1A. So even the Board of the BOR is treating this differently in terms of what they're looking for. So, and it's in the record.
Is that the appeal from the BOR to the BTA is when that form comes in there, or where is that form?
Sure, Your Honor. This is the actual form that it looks like at the BOR. So this is the first step really for the taxpayer. And on the back of it, it gives the taxpayers instructions, okay? And this is kind of important to this case because this is where the BTA got it wrong. In the general instructions, it specifically says that documents which are important to present for the case are things such as rent rolls and detailed income and expense statements for the property, okay? So why is that important? Well, that's important because that's exactly what we did. My client's a hotel. From January 1st through October 1st of that year, it suffered a 47% decline in sales. That business, they make their money by selling rooms, just like McDonald's would make their money by selling hamburgers. And for that type of property, which is an income-producing property, the value of the property is directly related to the sales. So, which is natural. Whereas if you have just your owner-occupied home in a residential area, it wouldn't generate any sales, you just live there. So you would value it as a different process, for example. So the BTA, in their opinion, they actually criticized us for providing the exact material that the instructions for the BOR hearings say to present, which substantiates the income approach for the valuation of the property. So hopefully that kind of like background sets the tone for what we think went wrong at the Court of Appeals. We were successful at the Board of Revisions, my client was. We got the property reduced from about 4.1 million to 2.6 million, it's just for that year, okay? So that is a 35% reduction. And the Board of Appeals awarded us that grant or that ruling, and that's exactly what we asked for. At the Board of Tax Appeals, the only people that showed up were my client. There was no Board of Revision there, no auditor there, no school board there. It was just us, and we presented the exact same information. So.
And that was the city's appeal?
I'm sorry?
That was the school, it's not the city, the school district's appeal before the BTA.
Correct.
You weren't appealing, you were satisfied with the number they gave, they appealed, not you.
Absolutely, Your Honor. We're very happy with the Board of Revision's decision, and we're asking the court to reinstate that. So the school board appealed the case to the BTA. So they were the appellant at the BTA, but if you look at the BTA's opinion, they're treating my client as the appellant. They're putting the burden of proof onto my client, and they're also stating the different standard of credible and probative evidence when the statute specifically says satisfactory evidence to substantiate the claim. So when the BTA goes through their analysis of reviewing the Board of Revision, they're supposed to go, approve it as long as the BOR's decision was plausible based on the evidence, okay? So in this circumstance, the only evidence that was presented was from us. There really was no evidence presented at the BTA to overrule the BOR's decision, which the BOR's decision overruled the original auditor's valuation. Once a BOR sets a different valuation than the auditor, that new valuation eclipses the auditor's valuation. And the BTA must perform an independent valuation and cannot simply revert back to the auditor's valuation. That's what they did in this case. And the rule in Bedford, in the brief, says exactly that. It's almost exactly on point with this case is what happened.
With this COVID, and I understand that's a known rule how things work. With this COVID statute, was it designed to say for the tax year 2000, whatever it was, it goes to 2.6, but in 2001 it's going to go back to 4 million unless there's a future filing by your part, or would that change the value all years going forward to 2.6?
Excellent question, Judge. It's for that tax year. However, by operation of law, and this may be honest with the court, the way that it works in our industry is that normally the local government, the auditor, or in this case the fiscal officer, because it's Summit County, they do a triennium and then they do a sextennium evaluation. So if you happen to be in a county where that year is the COVID year, it spreads for the triennium. So I have other cases in like Lake County where that's not the case, because they don't trigger on that particular year. So yes and no, I hope I answered that.
No, thank you,
properly.
you did answer my question.
Yeah, thank you. So just to go over what we believe that how the BTA erred is, obviously the
Can
financial.
I ask you one question before you get into there?
Yes, sir.
57-1704 talks about your notice of appeal.
I-
And it talked about the notice of appeal that was filed, and it sounds like, I understand, appellate are saying, look, the notice of appeal is deficient because you didn't say what the errors were in the notice of appeal you filed. Is that correct? Did you not have notice of your errors assigned in your notice of appeal? What do you have to say about that issue?
We did put issues in the notice of appeal, and then under the appellate rules, there's a precipice that goes along with the notice of appeal, which also specifically designates what the issues are in the notice of appeal. And we believe that that should be read like in para materia, together.
If we exclude that, though, you're still saying, I've not looked at the notice of appeal a little bit, you're still saying that the notice of appeal had errors assigned in it, just that document itself?
I believe that it's a notice issue. We're basically a notice pleading state. I believe that everybody was on notice that we're appealing this decision. So, and I understand Mr. Steve disagrees with that. I'm sure we will hear from him. But our position is yes, we complied with the statutory requirements. So, the BTA obviously didn't consider our rent rolls and detailed income and expenses. And they also basically wholesale discounted the owner's opinion of the property. And one of the reasons that the owner's opinion is so important to landowners is that it's burdensome and costly to go out and hire experts. The entire purpose of this special COVID statute was to provide financial relief to income-producing properties and things of that nature. And my client simply didn't have the money to go out and hire like appraisers to come in and do an appraisal. And also, the analysis was different. It asked for diminished value, not what is the ordinarily fair market value. Am I getting close to my time?
You get about 30 seconds.
Okay. So we would ask the court to look at that. The rule in Bedford is extremely, extremely important. And also, there are some other inconsistencies with the BTA opinion I can possibly go over in my other 3 minutes. Thank you, Your Honors.
May it please the court, my name is David Seed, attorney for Twinsburg City School District. To answer Judge Stevenson's questions, 57-15-19 is a statute that provides for a complaint to be filed with the Board of Revision. That's how the process starts. DTE 1 or 1A was described. Then from the Board of Revision, an appeal can be filed to the Board of Tax Appeals under 57-17.01. And there's a form that's prescribed by the Department of Taxation. An appeal can also be filed to the trial court, but in this case it was filed with the BTA. From the Board of Tax Appeals under 57-17.04, appeals can be made to the Supreme Court and the Court of Appeals from a BTA decision. Until about 10 years ago, tax complaints could be appealed to the Supreme Court or the Court of Appeals. The General Assembly limited property tax appeals to only the Court of Appeals, with then a discretionary appeal from this court to the Supreme Court. However, tax commissioner appeals from the Board of Tax Appeals can be appealed to the Supreme Court under the same statute. And 57-1704 states specifically, thus errors not specified may not be asserted as a basis of relief. I'm citing a decision, but the case, I don't want to say read from you from the case decision, but 57-1704 specifies that the errors have to be set forth in the notice of appeal. Okay, and unlike an appeal from the trial court to this court, where the assignment of errors can be provided with the brief, in an appeal from the BTA to the Supreme Court or this court by statute, the assignment of errors have to be delineated in the notice of appeal. Now, I'm looking here at the notice of appeal, and there are no assignment of errors. Simply, there's a statement that states, now comes the appellee, or now in this case, the appellant, Twinsburg Hospitality Group, which gives notice of an appeal, and then a certificate of service, and attached to the copy of the decision of the BTA. There is no assignments of error. And in the motion to dismiss and in my brief, I provided to you dozens of decisions from the Supreme Court and courts of appeals where appeals have been dismissed, where assignments of error are not specified in the notice of appeal. I'm not able to find a single case to the contrary. So this court, we respectfully ask this court to dismiss the appeal because that's the law in Ohio.
Well, their position is, despite that, in our, what I'll call the docket statement, they're called a precipice, in there we said, here are the errors we're going to assert. One, do you agree that that docketing journal entry, the docketing statement had those errors?
No, I don't agree.
You don't agree that it had them, or the fact is, doesn't matter, it still should be dismissed?
I believe I read in the docketing statement, there's a statement that an issue for review is the value of the property.
Okay.
That's not necessarily, I didn't see any specification of errors in anything that was filed. I could stand contrary if proven wrong, but the courts have held that it has to be in the notice of appeal, not in a additional document that you file. And what's, unfortunately, we can blame the General Assembly if we want, because many appeals are filed from the trial court to this court, where you can provide your assignments of error in your brief. It may lead a practitioner to believe that in filing an appeal from the BTA to this court, that practice was acceptable. However, for us tax practitioners, when you appeal from the BTA to the Supreme Court or Court of Appeals, there are various rules that have to be followed, and one of them is that the assignments of error have to be specified in the notice of appeal. And you'll see in the decisions again that the courts have just dismissed cases where they're not set forth. Furthermore, and
I have a question on
Go
the
ahead.
issue. What was the timing of you filing a motion to dismiss here?
I filed it right after his appeal was made.
So after you filed the notice of appeal, it was close in time?
Correct. I filed the motion to dismiss on September 16th of 2024. This court has not ruled on the motion to dismiss. Now, Appellee, Summit County Fiscal Officer, and Board of Revision have also pointed out errors in their own motion, naming of parties. You'll see in 571704, there's all sorts of rules that you have to follow. You have to name the auditor as a party. You have to give notice to the tax commissioner. They do not, General Assembly provides a lot of rules that are not in place for a common appeal from the trial court to this court.
And there's nothing that was unique to this COVID statute regarding appeals or anything to make it any different than?
No, sir. And I'll move on to that. The COVID statute merely allowed for one, a complaint could be filed after the March 31st deadline. I believe it was October 1st of 2021 for tax year 20. Because COVID obviously was occurring, as we all know very well, in March of 2020, to provide some additional assistance to taxpayers. Secondly, there was nothing in the statute that addressed the appeal from the BTA to this court or any court in Ohio, or from the Board of Revision to the Board of Tax Appeals. So there was no accommodation made. It was simply to allow for the filing of a complaint after the deadline had passed to file a complaint for tax year 20.
It does seem to adopt a different standard than satisfactory as opposed to the other standard that exists.
Okay, so I'll move on to that answer.
If you would, please.
Thank you. What taxpayer I don't necessarily agree. I think they use the language in the decision of credible probative evidence. Because yes, taxpayer did provide to the Board of Revision some financial statements. And all of you, I'm sure, have been trial attorneys and judges at the trial courts, and simply providing a financial statement or a piece of paper, okay, what the Board of Tax Appeals determined was not satisfactory or credible evidence for a reduction in the value of a income-producing hotel. And let me go turn this back a bit. What the Board of Revision process does is value a property. Typically, you'll have an appraisal. You need to quantify the value for one. A hotel is a going concern. When you go to a hotel, there's room, food and beverage, all sorts of revenue. Part of that's business value. Okay? That's not necessarily the bricks and sticks of the hotel, the personal property, all the equipment that's in the hotel. So typically you have an appraiser that will value a hotel and then allocate what the contribution is of the land and building, and then what the contribution is of the personal property. So what the taxpayer did here is simply provide the Board of Revision with a piece of paper, a list of financial numbers. And you think about it, no one would buy or sell a property, income-producing property, simply by looking at a single piece of paper for a single period of time to determine what the value is. You would look at future expectations, you would look at a history, you would look at comparable sales. You essentially, and in most cases, you would provide, in a tax appeal, an appraisal. An appraiser who is expert at that type of valuation could look at how COVID impacted the value of the property. So you'll see in the decision from the Board of Tax Appeals, they determined that the evidence that was provided, simply providing a piece of paper showing some reduction of revenue, was not adequate evidence.
Council has shown us held up the form that, if I recall correctly, was the Board of Revision was saying, here's what you have to present, and it was similar to what they presented, these kind of documents. So if they were going by the request, if you will, of the BOR, isn't that fair to use that type of evidence in front of them?
That's done in all tax cases. Board of Revisions have rules that say that for an income-producing property, we would like you to provide income and expense statements, rent rolls, anything that you feel that may assist your case.
So isn't the statute about relief, tax relief, it's not the same because it's about tax relief to the property owner during COVID? So aren't we talking about a completely different analysis here, a different statute than what we normally see?
No, it's providing an opportunity for a taxpayer to file the complaint past the normal deadline that they could file the complaint. It's citing that you can bring up the factors of COVID, which is what you're going to, but you still then have to take the next step, which is what the BTA found. How did that impact the value of the property? Okay, that's the key thing in these tax appeals is whether it's a COVID complaint or not a COVID complaint, is how does my evidence show a reduction in the value of the property?
And the BOR said it did.
Correct.
And you appeal.
Correct.
And I read the BTA decision to some extent, putting the burden back on the business owner, even though it was your appeal, to prove things. Shouldn't that burden have been on you to say, here's why this evidence isn't appropriate, and here's our evidence that shows it shouldn't be 2.6 or whatever they came up with?
I see your point, but I think the BTA has the discretion and the ability to review the record below to determine the credibility of that evidence. Analogy would be, because I do this work for most of my work, is I present a newspaper article to the Board of Revision, and the Board of Revision increases the value of the property. Taxpayer takes an appeal.
Well, that's the taxpayer appeal.
Correct.
That's the difference in your analogy. The taxpayer.
Right, but
It should be, that's my concern, is who's appealing.
Right.
Who that burden shifted to.
But what the taxpayer in my example would show is the evidence that was presented at the lower level was so inadequate, simply providing a newspaper article, that there was no basis for the Board of Revision to change the value. So coming back to this case, simply providing an income and expense statement for a hotel, the Board of Tax Appeals in its review determined that evidence was not adequate. Sufficient, credible, probative evidence of the change in the value. There's nothing in the record, here's the thing, there's nothing in the record that shows the value of this hotel. Simply providing a financial statement, we have a net income or certain, we have, and you remember, financial statements can include items like depreciation, amortization, mortgage interest.
And did you argue that at the BTA, that look, they have these things that aren't appropriate for our determination here, they have amortization and depreciation, you shouldn't look at that?
We argued that it was just not credible evidence presented, because simply, how can one determine from a financial statement for a single time period what the value of that hotel is? There was no, and then furthermore, I think the BTA, looking at it, there's nothing in the Summit County Board of Revision's transcript that shows how they determine the value of the property. Now, let me finish up that our key issue is one, that the Board of Tax Appeals decision is correct because of the lack of credible evidence. But secondly is, and more importantly in this case, is that the notice of appeal did not designate any errors for this court to review, and the Ohio Revised Code and decisions of the Supreme Court and courts of appeals respectfully mandate this court to dismiss the appeal. Thank you.
You have your full 3 minutes.
Oh, thank you so much, Your Honors. I'm going to try to go as fast as possible because it is only 3 minutes. So just a couple corrections. The auditor did not have to be named as a party to the appeal to this court. Okay, the statute says that they merely have to be submit a copy of the appeal to the auditor. They were not named a party. They were not a party at any stage of this litigation whatsoever, although they had an opportunity to do so if they wished. Regarding the precipice, in the appellant's brief in support of jurisdiction, my brief states that the notice of appeal was taken from the rules of appellate procedure, Form 1, Exhibit H, and that in that precipice, the statement of probable issues were, quote, value of real property pursuant to special COVID tax assessment, I put House Bill, but it's actually Senate Bill 57, owner's opinion, which we talked about, sufficiency of the evidence, which we've been talking about today. So again, we believe that everybody was on notice that these are the issues to be talked about today. Regarding the issue of whether or not the Board of Education engaged in any kind of argument or cross-examination at the BOR, they did not. There was a different law firm that represented the Board of Education at that point in time, and I believe I have some case law in my brief that says that if you don't cross-examine at that point in time, that's actually a waiver on that issue. Finally, I just want to close on the satisfactory of the evidence. My colleague talked about that a little bit, and I want to direct the court to page 17 and 18 of our brief. And this is the evidence, and there's a transcript in the record. My client testified that he was the owner-operator of the property. Prior to COVID, the property was doing well. The property is a hotel that serves primarily business guests. We know all that changed with Zoom. COVID-19 created medical and sanitation expenses and distancing costs. COVID changed business behavior by switching to Zoom remotely. This is all testimony from the BTA hearing. Mr. Chada, my client, personally compiled the evidence to be used. Mr. Chada is involved in the daily efforts of the property. His experience in the industry regarding purchase of hotels was discussed in terms of the valuation of the property and the diminished valuation. He testified that the property suffered a 47% reduction in value during that diminished time frame that we're talking about. This is almost a remedial statute, I think, to Judge Lanzinger's point. This is not really meant to be a long-term fair market value statute. This was meant to provide relief for suffering businesses.
I have a question on that point then.
Yes, Your Honor.
We know that the Board of Educations have standing to pursue these actions when we're talking about the regular statute, but when we're talking about remedial, Senate Bill 57, is there a standing issue here? This court can address standing at any point, even on appeal, without it being raised.
Your Honor, my 52-year-old brain is not working fast enough to answer that question sufficiently. But if it pleases the court, I would ask for 7 days to file a brief on that to supplement it. Because I want to give you the proper answer.
And
I just don't know.
There's a Supreme Court case tomorrow about a COVID statute and standing, and whether the standing, so I'm asking, when you have COVID remedial type of statutes, do the same people that would ordinarily have standing?
I don't know the answer to that question, and I don't want to mislead the court. But if you believe so, that might help us. So just to go back on the sufficiency of the evidence, my client testified that there's actually a formula for valuing these properties, and he's testified that it was about 3 times the revenue, because again, it was an income-producing property, which if you multiplied 3.5 times the revenue, which is the standard in the industry, you would get to approximately the value that the DOR cited with us. He also performed a cap rate analysis on the property, and he also discussed the issue of banks which were not lending to these types of property at all. So even if you had a willing purchaser at that time, they most likely could not even obtain financing to go through with the purchase. Why am I telling you all this? It's because if you look at the Senate Bill 57, it says, quote, any circumstances related to COVID-19 pandemic or the orders. And really, I think that those are kind of the key points.
You're out of time. You have about 10 seconds.
So we would ask the court to reverse the BTA, to remand it with instructions to reinstitute the Board of Revision's original decisions. Thank you, Your Honor, so much. Mr. C.
Thank you both for your presentations. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's decided, and the opinions are also posted on the Ohio Supreme Court website. Thank you.
Thank you.